There are really just two things that I want to do very briefly before we proceed and before I hand over the floor to Malcolm. The first, as always, is to acknowledge the land that we're gathered on today, which is, of course, Treaty 6 territory. And the Centre and I accordingly acknowledge and honour the ancestors, traditions, and spirit that first drew Indigenous peoples, including the Cree, Blackfoot, Métis, Nakota Sioux, Iroquois, Dene, Saulteaux, and Inuit to this unique gathering place. And in acknowledging the territory that we're on, we also acknowledge, firstly, that all of us here in the city of Edmonton are beneficiaries of treaty. And secondly, that such acknowledgement is only one exceptionally small, even minuscule, step in the ongoing process of reconciliation in Canada. So that's the first of my two small tasks for today. And my second task, of course, is to introduce the author. We're here to celebrate Professor Malcolm Lavoie. So most, if not all of you, will be familiar with Malcolm's bio already. But just to run through some of the key points, Malcolm is a professor here at the Faculty of Law at the U of A, where he conducts research in property law, judicial remedies, federalism, and Indigenous jurisdiction. And in addition to being the author of Trade and Commerce, Malcolm has also authored at least a dozen law review articles. He's co-edited several other books, and he clerked for both the Alberta Court of Appeal and for Justice Bella of the SCC. So it's a great pleasure to have Malcolm here with us tonight, and I'd invite everyone to join me in giving him a very warm welcome.
Thanks, Richard. And thank you all so much for being here for this book launch event. I'll try to keep this short because we have at least two guests, three actually, who are under the age of 5, including my daughters, Frances and Mary. Despite the fact that their names are on the dedication page, I suspect they're more interested in the cake than what I have to say about the book. So I'll try to make this brief. Tonight, I thought I'd tell you a little bit about the arguments in the book, but first I have a few people I want to thank, if you'll indulge me. First, my wife, Moira, who's here despite being approximately 9 months pregnant, without whom this book wouldn't exist. I'd also like to thank my parents, Cecilia and Mitch, who unfortunately couldn't be here this evening, but who provided support going all the way back to the beginning of my academic journey. I also have more than a few intellectual debts to acknowledge. If you look through the citations in the endnotes of the book, there are 3 names that come up again and again. One is Dwight Newman, who you'll be hearing from shortly. And the other 2 are Gerard Laforêt and Janet Agenstad. When you're writing a book of this nature, you can feel as if you're in a kind of dialogue with those who have written in the area before. And that's how I felt about those 3 authors whose work was so important in helping me think through the argument that I try to make in the book. I'm proud to say that Dwight is a friend of mine, but I've only ever met Justice Laforêt once, and I've never met Janet Agenstad. Yet I nevertheless feel a kind of connection and affinity with all 3 of them, as if we were toiling together in the same intellectual mine, even though we did so in some cases decades apart. I should also say thank you to the University of Alberta Faculty of Law for giving me the opportunity to join this esteemed institution and for supporting me in my scholarship, including, of course, this book. It's a privilege to get to work here. Whenever I walk to my office on the 4th floor, I go past the portraits of all the past graduating classes, and among the past graduates are my wife, Moira, and my mother, Cecilia. I know how much this institution means to so many who helped to build it up into what it is today, and I strive to be worthy of that legacy. Finally, thank you to the Center for Constitutional Studies and the Runnymede Society for hosting this event along with the Faculty of Law. All right, on to my book. So the book is about the economic constitution, by which I mean a series of commitments pertaining to economic relations that I argue are reflected in the Constitution Act 1867. Those commitments are secure property rights, local autonomy and subsidiarity, economic integration, and free trade. I've already told you a bit about my intellectual forebears, who in some cases were writing about these issues decades before I was in shortpants. But how did I come to this topic? Well, the short answer is a case called R.V. Como, the case of the retired New Brunswick steelworker who crossed the provincial border in order to buy some cheap beer in Quebec. As some may recall, Mr. Como was charged by police on his way back home, and his beer was confiscated. The offense? Essentially, possession of out-of-province beer. At his trial, Mr. Como argued that the provincial law he was charged under contravened Section 121 of the Constitution Act 1867. That provision requires that goods from one province shall be admitted free into any other. The trial judge actually agreed with Como's argument, citing the text, historical context, and purpose of Section 121. The trial judge held that the New Brunswick law was unconstitutional. I thought the case was fascinating, so after the trial decision came out, I wrote a short article providing a roadmap for how to reconcile the commitment to free trade in Section 121 with provincial regulatory authority. And then, when the case was heading to the Supreme Court of Canada, I was approached by a potential client, a small beer importer. The potential client asked me if I would like to make the argument in my article in an intervention at the Supreme Court. As a junior lawyer and law professor, I was so eager to say yes to that offer that I forgot to ask how much the file would pay. Turns out the answer was nothing. So off I went to the Supreme Court, pro bono. At the Supreme Court, I had a front row seat to one of the most abrupt reversals of a trial judge in recent memory. Second row, actually, with the rest of the interveners. At the Supreme Court, Mr. Como's lawyers came up against a wall of jurisprudential resistance to the idea that Section 121 was intended as a robust guarantee of free interprovincial trade. The court ultimately upheld the New Brunswick liquor law, offering a narrow interpretation of Section 121. According to the court, as long as a provincial measure is rationally connected to a legislative scheme whose primary purpose is something other than outright protectionism, it's fine. In this case, the scheme in question was held to be directed towards provincial control over liquor distribution, which is really more of a means than an objective, but in any event, Mr. Como lost. In a particularly illuminating exchange during the Como hearing, Justice Malcolm Rowe made a claim that seemed to encapsulate the approach the court would ultimately take. I won't attempt to do a Justice Rowe impression, but just so you can imagine, Justice Rowe is a Newfoundlander, known for being somewhat acerbic, even combative in oral argument. But he always lets you know what he's thinking. And in this case, in an exchange with counsel, he said the following. Now, you've said to us that essentially Section 121 is an anti-protectionist measure. You know, the Constitution Act 1867 wasn't a document that set out policies. It set out frameworks and competences. Why should we read Section 121 as incorporating a policy? In other words, Justice Rowe claimed that the Constitution is neutral on questions of economic policy. The moment I heard him say that, I knew he was wrong. And apparently I didn't get over it, because here I am 6 years later with a book trying to explain why I thought he was wrong. I'm actually grateful to Justice Rowe for being so characteristically candid, because his statement reveals a common misconception about Canada's Constitution. In fact, as I argue in the book, Canada's Constitution reflects a sophisticated vision of economic relations, one that is grounded in enduring principles of political economy. And the implications of recognizing that extend far beyond the proper approach to Section 121. So as I've mentioned, the book argues that the Constitution is committed to 4 key principles pertaining to the economy: secure property rights, local government, autonomy, economic integration, and free internal trade. Of these principles, the first 2 have a decentralizing tendency, placing economic decision-making in the hands of property owners and provincial legislatures. The last 2 principles, by contrast, have a centralizing tendency, seeking to promote an integrated national economy with secure channels for interprovincial trade. And the Constitution reconciles these competing principles in impressively thoughtful ways. While Section 121 directly reflects the Constitution's commitment to free trade, other provisions of the Constitution achieve their purposes through more indirect means. Two mechanisms are particularly important. The first is the separation of powers between the legislative, executive, and judicial branches of the state. In keeping with our British constitutional heritage, Canada's Constitution promotes secure property rights by limiting the power of the executive to infringe property rights in the absence of clear authorization from the legislature. Measures that tax or take property must be expressly approved by the elected representatives of the people, a point reinforced by Section 53 of the Constitution Act 1867. And through a series of presumptions, including the presumption against taking property without compensation, courts reinforce these protections, though always in a manner consistent with legislative supremacy. The second key mechanism is the exclusive nature of the division of powers between the federal parliament and provincial legislatures. Provinces are granted exclusive jurisdiction over most economic matters, allowing them to make decisions that reflect local circumstances, values, and priorities. The keystone of provincial economic jurisdiction is the power over property and civil rights, a phrase that at the time of Confederation was understood to encompass the full breadth of private relations, including economic relations. The property and civil rights power was central to the Confederation bargain. While some politicians, including John A. Macdonald, would have preferred a unitary state, robust federalism was needed to achieve the necessary consensus for Confederation, a point that was widely acknowledged at the time. At one point during the Confederation debates, Macdonald observed in the Assembly that he would have preferred a legislative union of all the colonies. At that point, his cabinet colleague from Quebec, Georges-Étienne Cartier, interjected, saying, "That is not my policy," to roars of laughter in the Assembly. Everyone knew local control over property and civil rights was the price of admission for centralists like Macdonald. However, at the same time as the Constitution vests broad economic jurisdiction in the provinces, the federal parliament has exclusive jurisdiction over a series of discrete economic subjects that can't be effectively addressed at the local level. Those subjects include interprovincial trade, transportation, and communication, as well as matters pertaining to the infrastructure of exchange, like currency and banking. It matters that Parliament's jurisdiction over these subjects is exclusive, ruling out overlapping provincial legislation. The economic subjects under federal jurisdiction often give rise to impacts outside a particular locality. In the absence of constitutional restrictions, provinces would be expected to enact policies favoring local interests at the expense of outsiders, including by erecting trade barriers. This is a classic collective action problem. If all provinces erected trade barriers, they would all be worse off. The Constitution responds to this inherent problem of federalism by limiting provinces' ability to affect economic interests outside the province. Similarly, the Constitution provides for the local autonomy of the provinces by providing that provincial jurisdiction over local matters is also exclusive. Federal legislation that overlaps with areas of provincial jurisdiction has the potential to undermine provincial autonomy. This is due in large part to the doctrine of paramountcy. Where federal and provincial laws conflict, the federal law prevails. In other words, the feds ultimately have the last word in any area of overlapping jurisdiction. Accordingly, the exclusive nature of provincial jurisdiction is crucial to provincial autonomy. Where there is overlap, the relationship between the provinces and the federal government is hierarchical, not coordinate. And the text of the Constitution is clear to the point of redundancy in stating that federal and provincial powers are meant to be mutually exclusive. Unfortunately, courts and governments in recent years have moved away from the Constitution's model of exclusive heads of power, adopting instead a flexible approach to federalism in which federal and provincial laws overlap considerably. The move towards flexible federalism has had unfortunate consequences. provinces are rightly concerned about the loss of local autonomy that comes with federal intrusions into areas of provincial jurisdiction, from healthcare to natural resources. At the same time, however, trade barriers erected by the provinces have been a persistent problem, undermining economic growth and prosperity. These trade barriers are ultimately the result of approaches to constitutional interpretation that give provinces wide leeway to affect interprovincial economic relations. So, the first part of the book is dedicated to outlining the economic vision of the Constitution. In the second half, I switch gears to argue that the economic vision remains relevant today, and that a renewed understanding of it can help to solve contemporary challenges, including those I've already alluded to. Certainly, much has changed since 1867, but the principal commitments of the Constitution remain relevant precisely because they are based on enduring aspects of human nature and the nature of political communities. Let's consider first the decentralizing features of the economic vision: secure property rights and local government autonomy. In a large and diverse country like Canada, local decision making is vitally important, and both property rights and the jurisdiction of local governments help to facilitate it, allowing for decision making on the basis of the different circumstances, values, and priorities of individuals, groups, and communities. Our understanding of the importance of local decision making has actually been further enriched since 1867, as has our society's appreciation for the range of political communities that are part of our constitutional order. That is particularly true with respect to Indigenous nations. Both Indigenous property rights in land and natural resources and the jurisdiction of Indigenous governments can serve to facilitate local economic decision making by Indigenous communities. Indeed, one of the pressing issues of our time is how to extend our constitutional order in a manner that makes Indigenous communities full partners in confederation. And in that respect, the division of powers between the federal parliament and provincial legislatures provides a compelling model for how to reconcile local decision making with national unity. And indeed, that model has already informed negotiations over modern treaties and self-government agreements with Indigenous nations. The Constitution's commitment to economic integration and free internal trade also remains relevant today. The idea of an integrated national economy with free trade across provincial boundaries tends to be supported by a large majority of Canadians across the political spectrum. Moreover, economic integration and free internal trade serve a variety of goals that are as important today as they were in 1867. Yes, free trade leads to greater economic prosperity, as the framers in the Confederation debates repeatedly emphasized. Yet economic integration and free trade also serve other objectives. They facilitate national unity. It has been observed that protectionism is the economic equivalent of war, treating one's fellow citizens in other provinces as if they are outsiders whose interests matter less. Economic integration counters that tendency, promoting national unity. An integrated national economy can also promote national security, a fact that was well appreciated by the framers and one that Canadians are starting to rediscover in an era of unreliable global supply chains. And the Constitution's protections for economic integration and free trade are ultimately grounded in basic principles of political economy, namely that local jurisdictions will be less likely than a national government to account for interests outside of their boundaries. Ultimately, the book argues for a renewed understanding of the economic vision of the Constitution, which I think will help address some of the pressing policy challenges of today. Accordingly, it's my sincere hope that the book starts a dialogue on the economic ideals that animate our constitutional order. I'll leave it there. Thank you all very much. I look forward to hearing the commentary from Jessica and Dwight. Thank you.
So, speaking of the commentary from Jessica and Dwight, we're going to hear first from Dwight Newman, who's joining us today via Zoom. So Dwight is a professor of law at the University of Saskatchewan. So a huge thank you, Dwight, to you for joining us. Hopefully you can still hear me when I turn away from the mic. But I'll hand over the virtual mic to you first for your comments on Malcolm's book.
Okay, well, good evening, and thank you for having me as part of this event. It's an honor and a privilege to engage with Malcolm's new book, Trade and Commerce, Canada's Economic Constitution. An honor because it's one of the truly important books on federalism in Canada in recent years, in my view, and a privilege because in the context of a subject matter not always attracting these adjectives, the book is both lively and fun. The book is also a model of clarity in some respects. In a manner we so often ask people to do, it gets its main argument out up front in the first line of the book with an 8-word thesis statement. Canada's Constitution reflects a vision of economic relations. That's to some a surprising claim. It's in any event an important claim, and it's a claim on which the book delivers. Recognizing the possibility of such a vision enables Malcolm to offer a comprehensive account of how different parts of sections 91 through 95 of the Constitution Act 1867 and some other provisions fit together. And it's a sophisticated book that recognizes the complex polarities of a constitutional respect for subsidiarity combined with a constitutional effort to solve collective action problems, and how both of those can be encompassed within the Constitution's rich economic vision. Malcolm's book recognizes some areas in which there are arguably slight imperfections in the Constitution's respect for a fully balanced approach to those two poles. To mention one, which emerges some ways into the book, and which perhaps shows an example of how the book could contribute to today's constitutional conversations in not yet fully realized ways, Malcolm discusses how subsidiarity could also imply a role for local municipal governance, which the Constitution embraces permissively, but not mandatorily. It permits the provinces to establish municipal governments, but doesn't require them to do so. That might have been the most sensible approach to this question in 1867, but it also perhaps speaks to an area in which the book could further enliven today's debates on a potential constitutional status for municipalities. Given that they have existed, we're now in a context of cities that are in some instances larger in population than entire provinces, which raises interesting new questions. Malcolm's book also hints at the need for attention to the spending power, the federal spending power, in a brief section in which he references the relative fiscal strength of the federal government and its taxation powers as compared to the provinces, and hints at the need for further discussion on the spending power, which hasn't attracted the extent of scholarship that it could. The book's lively discussion of events could seem to raise some complex questions about how the consistency of political economic vision that it ultimately describes was achieved. Malcolm discusses how John A. Macdonald's view of the future Confederation had to cede, in some instances, or in many instances, to other voices, describing even some of the livelier heckles put against Macdonald's vision in Parliament. What emerged in Confederation was at once a product of political competition, a negotiated deal in some respects, and a deal over which there was simply competition in others, and also a cohesive instrument demonstrating ultimately a coherent vision. Seeing this reality play out in Malcolm's book is thought-provoking on the dynamics of how political competition can produce an economically sound outcome in a constitutional negotiation. And thus, indirectly, in some respects, the book is actually an interesting narrative contribution to thinking in the field of public choice. Now, I said that Malcolm's book is not just lively, but also fun, and I stand by that claim, even in the context of students who sometimes find division of powers dry at times. Because everyone can find here also lively stories of the debates in which Macdonald, Langevin, and Cartier were engaged, and also stories of the creation of Nunavut that tell even of the food and music on the first day of Nunavut's existence as a separate territory, enlivening the book at various points with these kinds of interesting details. While the book lacks recipes for the dishes served on that first day of Nunavut's existence, it shows us ultimately how the Constitution has functioned as a recipe for an economically thriving Canada. In doing so, it also speaks to the present and future in important ways. And to wrap up, I'm going to mention briefly three of those. First, the book is thought provoking as a platform for further discussion of some further issues. It engages with so many parts of the Constitution in presenting a unified framework that there's also room now to re engage with the specifics of some of the examples that it cites. I've never seen a book treat so seriously the constitutional head of power concerning weights and measures, seeing it appropriately as part of the structure for economic exchange in the country. Now, I don't suggest that the book leads us back into a re examination of the weights and measures provision so much, but it makes us think newly about text that might otherwise seem mundane. And it engages in brief discussions of so many parts of Section 91 that it can generate thought on almost all of them, even while simultaneously grounding further discussion. For example, the topic, often considered not so fashionable, of the federal jurisdiction over banking receives important discussion on how it fits within the economic structure, even while it now grounds room to build upon the discussion and consider complex questions anew of the respective roles of provincial credit unions, and provincial contemplation even of efforts to try to facilitate room for new approaches like open banking. Second, the book offers a robust defense of the role of exclusivity in a modern form. Here, it goes against the so-called currents that some cases have referred to, the so-called dominant tides of cooperative federalism. But in doing so, it speaks powerfully, and Malcolm shows how it's actually essential to the purposes of the Constitution that there be respect for exclusivity, notably around exactly how it is not only that the Constitution respects subsidiarity, but also how the Constitution facilitates solutions to collective action problems in its more interjurisdictional dimensions. Now, I'm not sure whether Malcolm's new thought of replacing the idea of watertight compartments with water resistant compartments will take hold, but I think his defense, and a robust one, of the role of interjurisdictional immunity, for example, is a very important contribution that stems from considering the Constitution as a whole, and one of the matters on which the conclusion of the book wraps up, a very important one at that. Third, and finally, I'll just say this book reinvigorates the idea of seeing the Constitution in unified terms, asking, can we go beyond the Constitution Act 1867 and associated provisions at the time? Malcolm does that in some respects already in respect of some of his discussion of Indigenous rights law matters. But one could also ask questions about how one sees all of the Constitution together, the 1867 Constitution, along with all of the provisions of the 1982 Constitution. And Malcolm picks up one tremendously important thread with his claims concerning the economic vision of the Constitution. He simultaneously offers an insight into the sort of larger task that could be undertaken in speaking to the entire fabric of the Constitution and the various threads, but one of which he's drawn a tremendous attention to. It's a wonderful book. I'm very pleased to be part of today's event and congratulate him on the launch of this book.
Thanks so much, Dwight. So we're now going to hear from our second discussant tonight, Jessica Fleming, who's a practicing lawyer who just completed a stint with Reynolds, Mirth, Butchers and Farmer here in Edmonton. So Jessica, welcome to the stage.
Thank you. Well, you've heard the biographies, and I'm certainly no Dwight Newman. So the comments I'm going to make are going to be few, and I think related more to how this book, I think the importance of reading this book, I think for advocates and those practicing law and who take the development of the law very seriously. maybe 2.5, depends on how you count. But I think the central argument of the book is that the Constitution reflects an economic vision through centralization and as reconciled with local autonomy and subsidiarity, and that it does reflect a deep commitment to property rights. I think this book is also an argument, or is also demonstrates a profound argument with respect to constitutional interpretation. In a recent 2022 Alberta Law Review article, Justice Feasby summarized the term. Oh, sorry. Okay. Justice Feasby summarized the Supreme Court of Canada's evolving approach to constitutional interpretation, pointing to very recent cases such as the 2020 decision in the Queen and Poulin, as well as what we'll call Numco Quebec, the 2021 decision of Justice Brown and Justice Rowe on Section 12, and similarly the City of Toronto. We see that the Supreme Court of Canada is turning from a purposive interpretation in the abstract, which I think arguably lacked coherent or at least discernible limits, to an alternate method which focuses on the text, arguing, as Justice Brown and Justice Rowe did, that the text provides the anchor is actually the anchor of the analysis, and shows that, or argues that the meaning of the Constitution is informed by the historical and legal context at the time of enactment. I think I think Malcolm's book, I think what arguably this new purposive is a demonstration of this new purposive interpretation. And I think for lawyers, I think it's very powerful in the sense that, first, I think it's a great demonstration of how one ought to, or going forward, how constitutional arguments can be put forward, ought to be put forward, and I think how it should be done successfully. But I think even more salient, I think it shows that there's a great potential for new and novel arguments to be made and these have implications for future cases and similarly past jurisprudence. So, for example, focusing on the text of Section 53 as he does, and viewed within the context of the constitutional commitment to property rights, such as principles of no taxation without representation, i.e. that bills ought to be generated in the lower house, I think calls into question some of the regulatory charge carved out under Section 53, and again, calling into question some of the current state of our jurisprudence. Again, similarly, I think a renewed emphasis on the text of the Constitution, notably the fact that exclusivity is clear from the text, I think pulls away from the dominant tide of flexible federalism. This is not insignificant or of a past concern. The degree of overlap or intrusion on provincial jurisdiction is exactly what the Supreme Court is going to be facing in roughly 3 weeks. I think the argument that Canada's legal heritage does include an important and robust protection of property law, I think calls for a renewed appreciation of certain areas of practice, notably expropriation. The lack of judicial appreciation for property rights was highlighted in the critique of the CPR decision. Although it's been recently reversed in Annapolis, I think this book actually provides a very principled explanation as to why the court did what it did. Similarly, although, and I think we can expand that argument, or I think we can take this premise and broaden it to a certain extent. For example, and even in de jure expropriation, I think the contention that property rights ought to be taken seriously provide a renewed appreciation for the right at stake and the significance of its deprivation. I think that allows us to understand more fundamentally why compensation schemes are remedial in nature, and even outside of compensation, while certain processes and procedures ought to be given a certain reading, or how they ought to be construed. And although not necessarily legal in nature, I think it provides an interesting critique or vantage point into the policies and procedures put in place in expropriation, notably when authorities seem to analogize this type of taking to a market transaction. And as a brief final comment, I would say that my short time at the bar, I've spent it as a law clerk at the appellate level and at an apex court, where the goal is to assist the decision maker in developing the law. As an advocate, I think your role changes slightly. Obviously, you need to provide a result for a client, um, and you have a certain interest to advocate for. But I think you still have a principal obligation to do so in a way that develops the law in an intelligible and in a principled way. And in the brief time I've spent practicing law, I think I've developed an appreciation for or an understanding of the type of scholarship that I think is most useful to that role. And I think Malcolm's book is a perfect example of that. It shows a deep engagement with doctrine and principle without being so distract as to overshoot the mark and exclude certain audiences. I have no doubt that this book will be useful for anyone who takes the law and its development very seriously.
Thank you, Jessica. So I think this is the part of the night where we get Malcolm up to take some questions from you folks in the audience. So Malcolm, if you want to come back up, maybe we can take an initial question. And then Malcolm, you can also respond to Jessica and Dwight if you want to when you're answering the next question, or you can go straight to the question. So can we have a first question from the in-person audience? Right there.
Thank you, Samuel, and thank you to Jessica and Dwight for those comments. On the sort of Samuel's question, I say that there's this principle of subsidiarity, that the federal heads of power, federal heads of economic power, are generally on matters that can't be effectively dealt with at the local level. There's a functional explanation for why they're federalized. I make the point, though, that the criminal law power seems to be an exception to this. Criminal law is something that could be effectively dealt with at a local level. And so, I think it's there for non-economic reasons, and it's an exception to the framework that I set out. Not everyone agrees. I supervised a paper this semester by Talia Ferreira, who argues that yes, subsidiarity is consistent with the federal criminal law power. Not yet convinced, but she made a good argument. I do think, though, that the fact that criminal law seems to depart from this idea of only giving the federal parliament powers that can't be dealt with at the local level effectively, that does provide some word or note of caution in an expansive interpretation of the criminal law power, that it has the potential to undo parts of this scheme if it's given too much breadth. And it's something that Dwight Newman in his scholarship, he's addressed that idea, the relationship between subsidiarity and the criminal law power. It's a good question and an important question. And I think the best answer I can give is that there's need for caution and an expansive interpretation of the federal criminal law power. I won't say too much. I'm grateful for Dwight and Jessica's comments. I won't say too much about them. Dwight's given me a whole new research agenda with his comments, series of articles I could write, and that I'm going to think about for the future. So thank you very much for that, Dwight, and thank you very much, Jessica, for those comments. I admit I didn't have the practicing lawyer first and foremost in my mind when I was writing the book. So it's gratifying to hear that you see those connections between the book and practice. The Annapolis decision, it's interesting you mentioned that. The Annapolis decision was released on the last day that my publisher allowed me to have the proofs for review. And I talk about the CPR decision. This is the constructive taking decision involving essentially regulatory measures that are tantamount to expropriation. The court revised its approach in a way that's much more favorable to the argument in the book, but I didn't have much time to respond to it. And I do think you're right. I think Annapolis, the majority in Annapolis, reflects this idea of constructive takings and expropriation law more generally as a body of law that is about rights protection and that is embedded in this common law tradition of protecting rights to both liberty and property. And I think that's the sort of big difference between the majority and the dissent in that case. The dissent sees the doctrine of constructive taking or de facto expropriation in terms of a much more rigid analogy with formal expropriation. And thanks for the mention of Section 53. Section 53, it's been mentioned a couple of times. It's the provision in the Constitution Act 1867 that says taxation measures have to originate in the lower elected house, both federally and provincially. In recent decades, courts have created a series of exceptions to that, including regulatory charges that have served some regulatory purpose. The federal carbon pricing regime was upheld as a regulatory charge. And has also given a robust interpretation of the idea that the taxation power can be delegated to administrative agencies, which Peter Hogg and others have argued is contrary to the text, which says taxes have to start in the House of Commons. And so, I hope that, having had some success with constructive takings, perhaps I'll have some success with Section 53, the ultimate nerd provision of the Constitution. So thank you very much for those comments. Appreciate it.
Let's take another in-person question. Anybody else in person, Steve?
Thanks very much for that. I'm curious as to your take on what are the reasons that the courts have adopted in recent decades or further the stance towards cooperative. Is it just a kind of reflexive deference and concern about the legitimacy of what might be perceived as counter-authoritarian intervention into either parliament or the legal legislatures doing it, or is there something else that might explain why there seems to be a pretty robust consensus that this pragmatic, flexible approach is the way to go?
Yeah, no, I think that's essentially right. The question is about what's behind the move to cooperative or flexible federalism. And I think this idea of getting the Constitution out of the way of economic and other forms of regulation is a big part of it. To sort of allow for legislatures and Parliament to enact their regulations without these seemingly, the restrictions that can seem arbitrary at first blush, sort of saying, your regulatory regime is struck down because you intruded into the jurisdiction of the other area of government. There's a kind of sense in which the exclusive nature of the division of powers is a kind of unjustifiable formalism that we need to be more functional in sort of the modern environment of regulation. I think that's misguided. I do think that if it was just a matter of, formal doctrine says you can't do it quite this way, and so we're going to strike your regulatory measure down, that would be problematic in terms of the impact on democratic regulation of say, the economy. But when you recognize that there's actually an underlying purpose served by this scheme of exclusivity, a purpose that can't necessarily be served by deferring to legislative majorities in every case, then there's, I think, a greater justification for hewing to exclusivity to some degree. I say exclusivity shouldn't be absolute, that there is a need for a certain amount of pragmatism. We've learned that over the time since 1867. It's not realistic to have perfect exclusivity. But nevertheless, judicial interpretation has to give some weight to that textual signal of exclusivity because it actually does serve a purpose. Serves a purpose in facilitating economic integration, reducing barriers to trade, and also serves a purpose in protecting that provincial autonomy. Thanks, Steve, for the question.
So we've got a first question on Zoom, which I'll paraphrase. We basically ask for your thoughts on the impact assessment methods. Any predictions?
I think it's going to be perhaps closer than people realize. The experience of the carbon pricing regime might lead people to think that, well, this regime will be upheld as well. This is more far-reaching legislation. In order to uphold the carbon pricing legislation, all the Supreme Court had to do was recognize a relatively narrow power pertaining to minimum standards of price stringency for carbon. The potential implications of upholding the Impact Assessment Act, I think, are more far-reaching in terms of a conception of federal jurisdiction that is very widely encompassing, that uses heads of federal power as a kind of anchor to comprehensively regulate entire projects that otherwise in the past would have been treated as being under provincial jurisdiction. And so I don't have a prediction other than that I think it will be close and a closely divided court, and you'll see some really sharply differing opinions from the majority and the dissent, whichever side they're on, as to what federalism should look like. And the idea, frankly, the idea of exclusivity, I think, is going to be central to some of those divides. The Impact Assessment Act is far-reaching, but it does take time to anchor itself in heads of federal jurisdiction, and then say, well, the fact that this affects, say, navigable waters or affects indigenous lands is enough for a pretty far-reaching and somewhat comprehensive regulation of an entire project, including the power to veto that project. That's basically what I've been talking about, this idea of secondary or ancillary intrusions into the jurisdiction of the other order of government. And so I think we'll get some interesting decisions there. I'm not going to predict it, other than to say it's close. It'll be close. And I think the idea of flexible versus exclusive conceptions of federalism will be part of that discussion.
Let's go back in person again. Any other questions from the in-person audience? I think we have time for one more.
I think people want cake. That's a surprisingly complicated question. It does vary by provinces now. The federal parliament amended the federal legislation that prohibited this and essentially delegated it to the provinces to determine when and under what circumstances you can import beer and wine from other jurisdictions. I think Alberta is fairly permissive among the provinces, so you might be all right. I don't know of any sort of sting operations catching people at the border like they have in New Brunswick, but it varies to answer your question. Yeah.
So if people want to proceed to punch and cake, which I think is a wonderful idea, I'm just going to briefly invite Chris from Runnymede to come up and say a few words. And then I'll say a few words, and then we can go for punch and cake.
Well, thank you so much, Richard. As he said, my name is Chris Kinsinger. I have the privilege of serving as the National Director of the Runnymede Society, and it's great to be back here in Edmonton. There's such a lively legal community here, and of course, the Center for Constitutional Studies is a big part of that. And I think this is actually the first time Runnymede and the Center have co-hosted an event together, so we're very excited to do that. We've had a lot of back and forth between our members over the years. A number of Runnymede members have contributed, for example, to the Constitutional Forum, and we've had members from the Center appear at our events, including Pat and Stephen, and of course, Malcolm. So we're really thrilled to be here, and thank you, of course, to Talia, our U of A chapter president, who's been working very hard with Richard to put on this event as well. And I just wanted to conclude by congratulating Malcolm on this book, which marks, in my view, the latest entry, if I can riff on what Dwight said for a moment here, in an emerging genre of legal scholarship that is both lively and surprising in how it takes these areas of the received wisdom about how we think about our Constitution. And so in this case, Malcolm, Justice Rowe's comments during the Como hearing that the Constitution is silent over economic policy. And it takes these areas of received wisdom and it really interrogates them head on by going and looking and grappling with some of the overlooked aspects of our Constitution. And so I'm thinking here about books that have come out in recent years, such as Ryan Alford's book, Seven Absolute Rights, or Derek Ross and Brian Bird's edited collection, The Forgotten Foundations of the Canadian Constitution. So congratulations on this accomplishment. Hopefully it is the first of many entries that you will make in this emerging genre. But with that, I will turn things back over to Richard so that we can all have cake.
And for exactly that reason, I'm going to keep this very, very brief. So I just have a few thank yous to go through, and then we can go for cake. So thank you, first of all, to everyone who's turned out for this. It's great to see so many people here in the new student lounge. An extra special thank you, of course, to our three guest speakers, Malcolm, Dwight, and Jessica. An extra special thank you to Malcolm for writing the book that obviously brought all of us here tonight. And then a final extra thank you to the U of A Faculty of Law, firstly, and then Chris and Talia and the Runnymede Society, secondly, for co-sponsoring this event with us and helping us to make it possible through advertising and funding and a range of different things. So that's all for now, but as you know, there is cake and refreshments at the back, so please proceed that way, and we'll hopefully see you again for another event soon.